Good evening. Welcome to the University of Michigan Club of Washington, D.C.'s virtual event, U of M Law School's Catharine A. MacKinnon, The Legal Meaning of Sex, Sexual Orientation, Transgender Issues, and Sexual Harassment. My name is David Koss, and I'm with the U of M Club of D.C. In her New York Times column this summer on the Supreme Court's decision in Bostock v. Clayton County, Linda Greenhouse wrote the following. In his dissent, Justice Alito wrote, Title VII prohibits discrimination because of sex itself. A quick computer search finds such terms as sexual harassment, sexual assault, sexual violence, sexual intercourse, and sexual content. Alito added, does the court really think that Title VII prohibits discrimination on all these grounds? Linda Greenhouse goes on. Justice Alito's computer evidently didn't inform him that in 1986, 24 years after the passage of Title VII, the Supreme Court recognized sexual harassment as a form of sex discrimination. The case was Meredith Savings Bank v. Vinson. The opinion was by William Rehnquist. The vote was 9-0. Sexual harassment had not entered the lexicon until 1979, when a law professor, Catharine A. MacKinnon, published a path-breaking book, Sexual Harassment of Working Women. What becomes a legend most? This evening, it is an opportunity to discuss some of the noteworthy achievements of her long career practicing and teaching law, extensive scholarship, and tireless advocacy, along with the backstories to many of the cases and controversies in this vital area of law and policy in which she has participated. Catharine A. MacKinnon is the Elizabeth A. Long Professor of Law at the University of Michigan Law School and the longtime James Barr Ames Visiting Professor of Law at Harvard. She holds a BA from Smith and a JD and PhD in political science from Yale. Catharine specializes in sex equality issues under international and domestic, including comparative, criminal, and constitutional law. While in law school, she wrote Sexual Harassment of Working Women, which with her co-representation in the Supreme Court led to the court's unanimous decision in Meredith Savings Bank v. Vinson, recognizing sexual harassment as sex discrimination. This past term Supreme Court case, Bostock v. Clayton County, holds that the federal statute barring employment discrimination on the basis of sex applies to gay and trans individuals when they are fired for that reason, and it follows in several ways from that early work in the holding in Vinson. Professor MacKinnon will explain all of that this evening. Her most recent book, Butterfly Politics, Changing the World for Women, is a collection of her career's breakthrough moments. I hope there will be time this evening to learn how butterfly politics moves the law, culture, and public discourse. Professor MacKinnon will be in conversation with a former star student at Michigan Law, Mark Spindelman, the Isidore and Ira Tauber Professor of Law at Ohio State's Moritz College of Law. Professor Spindelman is also one of the country's leading scholars in this area. His 6-part essay, The Shower's Return, a serial essay on the LGBT Title VII sex discrimination cases, is on the list of recommendations that will be provided toward the end of tonight's conversation. Professor Spindelman is also presently working on commentary on the Supreme Court's Bostock decision, called Bostock's Paradox, due out next year. Say that 10 times fast. If time permits, Professor MacKinnon and Professor Spindelman will take questions. Please feel free to post them via the Q&A feature. This is a Zoom webinar. Professor Spindelman, let me ask you to begin. Mark?
Thanks, David, and thanks for organizing all of this conversation. It's so wonderful to be here. And Catharine MacKinnon, it's so delightful to see you. I'm so happy to be with you to spend some time talking about your work and its significance in the new big LGBT cases. So I guess I want to start a little bit sort of both in the midst of Bostock and the cases it collects, and then at a little bit of a distance from them. I thought maybe we could start our conversation with a point from the oral arguments in Amy Stevens's case when your work came up. By way of background, for those who may not know this, Stevens's case was one of 3 separate cases that Bostock collects and decides. It's the case that asked the court to determine whether anti-trans discrimination is sex discrimination under Title VII. During oral arguments in the case, Justice Ruth Bader Ginsburg, in an exchange with U.S. Solicitor General Noel Francisco, noted the importance of sexual harassment law as a lesson for the court to follow in Stevens's case. Justice Ginsburg mentioned a book that changed the law in this area, a book that argued sexual harassment of working women is sex discrimination that Title VII bans. Now, Justice Ginsburg didn't mention the title of the book or the book's author by name, but in context, it was clear that she was talking about your sexual harassment of working women. This work, your work, obviously inspired Justice Ginsburg as she inspired us. Given that this is your first interview in the US since Justice Ginsburg's passing, I was wondering if you might like to start out conversation tonight by sharing some thoughts about her and her legacy in law.
Yeah, and hi, Mark. It's wonderful to be here with you. You being introduced as a former STAR student, you are always a STAR, only a former student. Yeah, Ruth was always really generous to me and my work. She was asked about it actually in her confirmation hearing, and amazingly refused to disavow it. Our work mutually influenced each other's, although since she preceded me by a good many years, hers lay the foundation for mine and also provided something of a fulcrum for it. She, before her litigation, the Supreme Court had never encountered a sex-based distinction in law that it didn't like. And she changed that in 1971. For the first time, there was such a thing as sex-based distinctions that violate the Constitution. The Supreme Court in that case, and following her analysis, adopted the conventional approach to equality, which comes from Aristotle actually, and it's premised on the idea of treating likes alike and unlikes unalike. Ruth took the view that the best place to start with establishing sex discrimination is where the sexes are the same. And of course, there's a great deal of sameness. There's a huge amount of overlap with women and men in the conventional sense. So that case did that. At the same time, her early arguments, and in fact, her arguments all along, recognized a deeper, darker, more substantial and historically questionable inequality between the sexes, and used the term subordination of women. Occasionally talked about inferiority. Now, the Supreme Court, on the whole, didn't adopt that in her early cases. So the basic paradigm was where the sexes are the same. Well, if you're being subordinated, you don't get to be the same. You don't have access to the biography and to the advantages and resources that permit sameness. And that's true for all disadvantaged groups. But in any case, when I started working on sexual harassment as a legal claim, which I did in law school and created it in the form that the courts eventually accepted it, it was clear to me that this fundamental sameness idea was not going to produce equality for women if it was the foundation of the legal paradigm. And I thought we needed another one, a different paradigm, a paradigm that actually recognized domination and subordination as the problem of inequality, not sameness and difference. So that, it's clear that if Ruth hadn't done what she did, it wouldn't have been in any way as possible for me to do what I did, both conceptually and in working with and against it, and legally speaking, in building on the foundation that she established.
Thank you. I want to talk a little bit more about your work as a kind of foundation for the conversation about Bostock that we'll be getting to and in a minute. But since what we're going to be talking about is about how you see Bostock and its twin holdings, that anti-gay and anti-trans discrimination are unlawful forms of sex discrimination under Title VII, I thought it might be helpful to start discussion by hearing from you some words about how you understand discrimination against lesbian women, gay men, and trans people to be forms and practices of sex inequality.
Well, sure. Since I've been teaching that exactly since when 1979, I guess, is the first year that I taught at Yale Law School, with a course called Sex Equality. And there was a whole chapter, a collection, a week of materials called Lesbian and Gay Discrimination, or Lesbian and Gay Equality, it was actually called, which at the time was an aspirational term entirely. The trans issues, I will get into the substance in a second, just getting the dates down here. I completely tranced my casebook as of the year 2000. So my sex equality casebook, which was published in the year 2001. So all that time, contrary to Justice Kavanaugh's dissent in Bostock, where he says, absolutely nobody thought, that discrimination against gay people and trans people was sex discrimination. Both he and Alito are quite certain that nobody even imagined this strangeness of an argument, novel and creative as it was termed by Justice Kavanaugh. Thank you. In any event, it was pretty novel in '79. I have produced two arguments for actually gay and lesbian discrimination and discrimination against trans people are two entirely different sets of arguments. The issues are different issues. Why they decided to do this together, I don't know. That they did it in this, as they call it, textualist, which actually is literalist, as Kavanaugh puts it. I'm all for literalism. Used to seem to me that feminists were the last of the great literalists. It says here equality, see, like, how about it? But in any event, they put them together, and the resolute opinion by Justice Gorsuch for the majority made swift work of putting the two of them together, and made it persuasive, compelling, logical that they belong together. But I want to say that the issues are different, and they are most the same, taking the approach that was taken by the majority in Bostock, in which I used to call the stupid theory of equality, which I called it that. I mean, I've taught hundreds and hundreds and hundreds of students this stuff, okay, for decades now. So it's not like nobody's ever heard of it. I call it the stupid theory of equality because it was so simple, it seemed smart people couldn't understand it, although none of my students ever had any trouble. And the argument is simply to say that if say a gay man, or if a man is with a man, sexually or in a relationship or in a primary committed couple, and is discriminated against for that reason, that would not have happened to that man had it not been for his sex, male. Had he been a woman, in other words, but for sex, which is the argument we established in the sexual harassment cases definitively, the discrimination, he would not have been discriminated against because the relationship or couple would have been a heterosexual couple, okay? Now, that was seen to be something of like a trick argument or something, like something that was like, I don't know, people acted like you were trying to pull something over on them when you made this argument. Or say there were two women who were together, and they were a lesbian couple, and one of them is working and she has a picture of her partner on her desk, and someone comes in, sees that, asks her about it, she explains, she gets fired. Okay, now, if she herself either had a picture of a man on her desk and that was her partner, or if she herself was a man and got fired, or wouldn't get fired to start with, then that's just plain heterosexuality, and that is why it's discrimination when you do it when someone's a woman. So there actually are years and years and years of at least some litigation, actually all of which is in my casebook and has been in it all along, attempting to tackle this problem of discrimination against gay men and lesbian women from a sex equality standpoint. A lot of the gay rights movement decided it didn't want to pursue that anymore because it seemed like it wasn't winning and went after privacy instead, and we could talk about that some. But actually there's a second argument. You asked me my approach to this. An argument in parallel to that, which I was sketching a minute ago, in contrast to that of Ruth Bader Ginsburg as principally accepted in her Supreme Court cases that she argued. Although by the time it came to the VMI case, which she wrote, she actually made very clear that it was the imposition of inferiority on women that is precisely what is prohibited by the Constitution under sex discrimination. So she actually moved the court somewhat further in the direction of this second argument now, the domination subordination argument that involves superiority and inferiority rather than sameness and difference, which is just, you know, the level line unequally divided more or less. Whereas the domination subordination argument is a top-down argument. Some people better than, worth more, valued more, paid more, elevated, respected, given dignity, given voice, given power, allowed to be leaders, etc. That is, you know, men and women with men on top and women below, and also straight people on top and lesbians and gay men beneath them, okay, which is another hierarchy. So this is a hierarchy theory. And if you look at sex and realize the place of heterosexuality in it, actually the dissent of Judge Sykes in the Hively case teased this up rather nicely by being dead wrong about it. He says that heterosexuality is not a stereotype of any kind in his terms. But actually heterosexuality is a male dominant, it contains within it a male dominant stereotype. That is the stereotype that men dominate women sexually, that men are active in sex, women are passive, men initiate sex, women receive that initiation. It's as if the image of the sperm and the egg dictate how men and women interact. So here's the egg sitting receptive, quiet, fat, full of nutrition, unmoving, immobile, like waiting to be penetrated by the little tiny, active, aggressive, fast swimming, smart, seeking out sperm. Boom, you know, there we have, okay. So that's the stereotype that heterosexuality is predicated on, building in to sex roles that by nature, women are properly subordinated to and passive to in relation to men who are by nature active, aggressive. If they take it a little bit too far, you know, we get all these nice gray areas around rape, etc. But that's a boys will be boys moment, okay. Now, what happens with gay men and lesbian women is that they both challenge this structure in distinctive ways under this second theory. Under this second theory, gay men challenge male dominance by, in the homophobic view, one of them being receptive to the sexual initiation or aggression of the other. In other words, the homophobic view can only see sexuality in these top-down ways. And the whole idea that there is a man who is on the bottom of another man who is on top of him, penetrating him, is an abomination, is anathema. And the reason why is that it destroys the biological basis on which male supremacy, its ideology, is founded, which is to say the inferiority, i.e. receptivity, penetrability of the female. Okay, so that's, and then that tells you a lot about violence against gay men, why especially feminine identified gay men are the ones who are so frequently targeted for lethal attacks and so on by homophobic aggression. So that's their challenge to male dominance by challenging the essentialist biological basis of heterosexuality, and hence all the roles that are socially predicated on the lie that it's natural. Okay, then lesbian women, for their part, challenge heterosexuality by making men irrelevant to women and women's sexuality. Men take great exception to this, and actually to both, that men can be penetrated sexually and that women can have a sex life and be sexual without men. There being no man around. They're not practicing up, they're not, waiting for the guy to come in, a la the pornographic usual stereotype. They're not wishing to be watched by men who wish to watch them, etc. So that also removes the idea that men are essential to the sexual experience, and hence to heterosexuality. It's a challenge to heterosexuality and its place in male dominance. So that's that. Now the trans issues are both different and simple, much simpler. They're different because the trans issues are fundamentally gender issues. Sexuality has a place in gender, and gender has a place in sexuality, but trans issues are about gender totally, gender as a whole. Not even principally about sexuality, to be honest. And so therefore, the primary challenge to male dominance that is posed by transgendering is simply that social roles, which are gender, are not unchangeably fixed in relation to the biology of sex. You don't go from the biology of sex to the gender of a person in any single simple way, in any absolutely determinate fashion. It's actually fairly indeterminate, and it takes a lot of social pressure to create social gender roles out of biological sex. And so what transgendering does is to say that other factors than biology are more important in what one's gender is. And those factors include identification, experience, politics, a whole roles, a whole range of issues. And if, in other words, if a person can change their sex by changing their gender, sex isn't biologically determined in a way people had thought it was, and gender overwhelmingly is not. Gender, as again, being the social meaning of sex. So that's, then it completely blows up the ideology of the naturalism of gender in particular as being sex-based.
Thanks. That's so helpful as a way of understanding the framework that you're working within and we're working within when you were litigating cases like Meritor Savings Bank against Vinson, arguing that sexual harassment is a form of sex discrimination, the same kind of thinking that was animating the important brief that you filed in On-Call against Sundowner Offshore Services to argue that same-sex male-on-male sexual harassment is covered by Title VII sex discrimination ban. These cases are hugely important to the larger body of sex discrimination or sex equality law in the ways that Justice Ginsburg's remarks during oral argument pointed out, recognizing the significance, the foundational significance of your work. I guess I'd like to invite you to, in a sense, go back to Justice Ginsburg's observations and share some of your own views about how Bostock reads to you as an outgrowth of your work on sexual harassment law.
Yeah, I actually, in preparation for this, took a look at my 1979 book on sexual harassment of working women and discovered it predicts Anka. It's plain says that there's a moment in sexism where male supremacy and homophobia converge. And that could well be a moment for a crucial decision for women and for gay men in a same-sex sexual harassment case in which a man is sexually aggressed against by other men and courts understand it as sex-based. And by God, they did. That was Anka. And I was kind of stunned to find this in this book. And the way we argued Anka was we did not argue it as a same-sex case. We argued it as a case of men aggressing against a man, and it was the man who resisted that aggression. This wasn't anybody nicely asking, did he want to have sex? You know, this is them jumping on him in the shower and penetrating him with a bar of soap. This is, you know, holding him down and waving their penises and batting him around the head with them and so on. This is assault, okay? And he did not want to be assaulted. People don't. And so it had nothing whatever to do with anybody's sexual orientation. It wasn't about the sexual orientation of Mr. Ankal or of the aggressors. It was about the male dominant sexual practices of those aggressors against a man who did not want to be aggressed against. And that's the way we argued it. But once we won, it's worth pointing out that here we have the first victory in a sex equality case in the US Supreme Court in a same-sex context. And you go around talking about that for 10, 15 years, it starts to penetrate. You know, people start to understand, oh yeah, that's exactly what we did there. It was a same-sex context. We found it was sex-based. That is, in law it was. And he had a legal claim that he could go forward with there. And it wasn't not a legal claim because the sexes were the same. So all the cases, and again, where is that history in all this? You know, you don't have to have it in the majority because they did their own thing there. But, you know, in both the dissents, they have this long song and dance about how nobody's ever heard of these arguments about how sexual orientation is part of sex discrimination, for example. And there again, with sexual harassment cases, people did try to argue that. Sometimes they won. And those didn't go up any further, but they are there. Sometimes they lost. But it's not as though this may be new to Alito and Kavanaugh, but it is not new to the litigation community that has been pursuing it, nor actually is it new to the original gay liberation movement, which understood itself as actually allied with feminism in questioning compulsory heterosexuality, as Adrienne Rich called it, and understood the unity of opposition to the subordination of women on the one hand, and forcing people to have sex only in a certain way and only with certain people in a way that was oppressive to women. And actually, I don't know what you call forcing men to be dominant. But the early gay liberation movement disavowed that as well. not only didn't want to be dominating women, but did not think that a sexuality of dominance was a sexuality that it wanted to claim as liberatory for men, and argued gay liberation in those terms. And similarly, lesbian women argued that the early politics, as well as continuing on, there's always been a critique of male dominance in lesbian feminism, and from early times. So these arguments aren't this newly, absolutely novel, no, who's ever heard of this argument.
Yeah, thanks. So I want to jump ahead to the decision in Bostock itself that Justice Neil Gorsuch handed down for the court, announcing for the first time formally recognizing the historical dimensions that you were pointing out coming out of Anka, that anti-gay and anti-trans discrimination is actually covered by Title VII sex discrimination rule. You mentioned this before, Justice Gorsuch's opinion sort of cloaks itself, describes itself as a practice of textualism, of giving sort of deference to the clear language of the statute. But as I'm thinking about sort of the way that Justice Gorsuch's opinion is written, and thinking about the sort of transformative possibilities of your theorizing as you described it, I wonder if you can sort of help us understand a little bit better how you see the theory, which is so transformative, and the textualism, which is a decision, sort of a textualist approach by a conservative Supreme Court justice, what that textualism does to the real radical or transformative potential of the theorizing that the cases actually grow out of.
Well, as I'm glad they did it at all. And I think it's well within the way they understand their role and the tools they have, with which that majority feels most comfortable to say what they said. Now, I also think there's growth potential in this in a way that is in no way shut down by the way they did it. By saying it's textualist doesn't mean it isn't an interpretation, all right? But the growth potential that I see in it is they say it is impossible to fire someone based on being gay or trans without taking sex into account. Now that is just dead on accurate, okay? It is true. You can't do it without doing that. But that doesn't mean that there aren't other ways of taking sex into account than this particular simple textualist way that are foreclosed by this. It also doesn't go further it doesn't go any deeper than it had to. One could say it's under-theorized. I think that would be true, but it's only under-theorized from the standpoint of a deeper theory. And it doesn't preclude that, I don't think. What does because of sex mean? It doesn't foreclose that we can make deeper arguments when we have to have them to reach the deeper issues. And meantime, people can't be fired because they're gay or lesbian. I think, when they say it requires treating people differently because of sex, to fire them, to discriminate against them for being gay or trans, that is an opening for us, as well as a decisive shutdown of all the noise that has ever said sex has nothing to do with it. The other thing that I liked about what they did, I liked quite a lot about what they did actually, making it so simple, was the way they said acts or traits. They didn't, go into the deep water of, is this about what you do or about who you are? Is this your identity or your behavior? Is this, blah, 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 blah. It's, they're done with that piece too now, which is endless in the former litigation, in the military cases, in the sodomy cases, all of that. It's like, wait a second, we can make illegal what people do. It isn't the same thing as making them, a criminal for who they are, and on and on and on. And this just goes acts or traits, gay or trans, is sex, out of here. If you're firing somebody because of it, that's what we're deciding. That's what this is. And then now there will be deeper, harder questions. And, that will call on us to give deeper analysis. But, this wasn't that. So actually, I thought it was pretty great. I loved actually the voice of the thing. The whole no elephants in mouse holes, okay, so it's an elephant. Where's the mouse hole? It's like, you have trouble with bathrooms, locker rooms. We don't have bathrooms and locker rooms in this case. When we get them, we'll think about them. That isn't this. These employers simply said, that's what we did. This is why we did it. So just so far as this particular case goes and the way it was written, as they say, it may be both unexpected and important, but if it's clearly commanded by law, here we are. It was kind of breathtaking to me to say something so simple, so obvious in such a simple and obvious way.
I think that's so hopeful. I really, I'm sort of feeling the hope. It's really terrific. I want to make sure we have some time for questions from the audience, but I want to ask a question from one of my amazing students who has been closely tracking developments in the Bostock decision and who has read your work. I know she's read your work because we've read it together in class. So I know she appreciates it deeply, deeply. She understands your work to involve group-based analytics in the ways that you were describing hierarchy, and understands Bostock as the Supreme Court handed down the decision to be a case that's emphatically following the language of Title VII about individual rights. Indeed, the group-based arguments in Bostock, insofar as they came up as expressions of defense positions in the case, with some echoes, I think, in at least Justice Kavanaugh's dissent. I guess I'm wondering, here's the question from my student, whether you would talk about Bostock's insistence that Title VII is an individual rights statute and how you understand that position.
My first thought about it is that, having again taught this for like 4 decades now, the only days that I could get passionate about the individual business was on gay rights and trans rights. And there's a reason for this. It's because the courts have failed to give women as a whole rights that we are clearly being denied on the basis of sex as a group, by saying this has got to be done on an individual basis, when in fact a lot of those issues are not individual issues. For example, comparable worth. It's, you know, a whole group of people who are not paid equally because they are women, actually. And unless you can prove it's intentional and blah, blah, there's no relief there. Then they come to gay and lesbian issues. And all of a sudden, they aren't giving anybody any individual rights. Then I get real passionate about individual issues. So I see where they're coming from about it, but I just want to now make this observation. And that is, whenever you do a Title VII case or a constitutional case on the basis of sex, race, the two together, all of those, the grounds are always class-based grounds. So what did you get out of Bostock? They say individual. Who does it apply to? Every individual to whom it applies, which is to say a whole group of people, because it's on the basis of sex. And everybody to whom it applies, you don't need a class. Good thing, because they've made it almost impossible to get one. But you don't need a group per se to have it have group-based application. It obviously applies to the group because it applies precedent-wise to everybody who is able to characterize their circumstance as similar to these circumstances. And regrettably, there are many of them. That's a group. And also, you know, sex is itself a group-based claim. Race is itself a group-based claim. In a sense, not in the technical sense, but actually in the philosophical sense, in the theoretical sense, in the political sense, all these cases are group-based cases. All discrimination cases are group-based cases, because it's your position in the group that gives rise to the discrimination that you're claiming. And that is either yourself, but you're not all alone in it, you know. If it hadn't been for the history of it, which actually, who is it who gets this? I think it is Alito who gives us this. Yeah, he says, okay, there's the racial analogy. That's his version of my second theory. Well, obviously, history tells us, I think he said, that prohibiting interracial relationships is a core form of race discrimination, end quote. Now, what does history tell us is a core form of sex discrimination? Well, if you really ask that question, you would start getting the answers to the experience that gives rise to gay men, lesbian women, and trans men claiming discrimination on the basis of sex. And, you know, if it weren't for the core forms of discrimination that contextualize their experience, no one would recognize that it was based on sex, least of all them, you know, far less a court. Now, the fact they didn't articulate it just means that it's left for us to articulate. But I guess finally, Alito himself understands it for race. Wow, now I want to see it deliver to people of color in a case where it actually matters, where you get to argue the history. This is a core form of that problem. You know, in other words, people often have more rights by analogy than they do directly, you know, when they are actually trying to get them. And that's certainly true for the racial analogy in many of these cases. But I just use that to illustrate that there is a comprehension of the class basis of race, which he then called history. That's fine, call it history. That's big, that's a group, that's a lot of people back there. It isn't just an individual. It contextualizes the individual, but context is always collective. And, you know, therefore, the meaning of the term as it applies to it, you don't get discriminated against on the basis of sex all by yourself, even if your claim is for you as an individual. And then if you win or lose, you don't only affect your own situation, you affect the situation of all people whose situations are like yours on the ground that you claimed. So I'm just saying there's an intrinsic class basis to it.
Great, thank you. That's wonderful. I want to turn to the dissents, which we haven't talked all that much about. And here I want to just sort of have the question be somewhat open-ended. What do you think when you read the dissents?
Oh, yo. I thought, well, Kavanaugh's was interesting to me in ways, both of them were interesting actually, in that they both were at some pains, although not overly so, to make clear that they thought the policy outcome was okay here, that they were like for these folks, that they are for these rights. In fact, they themselves personally, they just thought that it wasn't for judges to do. So they're saying this is legislation. You know what I really thought? I thought this reminds me of talking to people in France about sexual harassment. And the reason it did is because, and other countries that have civil law systems, the reason they say it's legislation is because there's another word for it. And the reason you need to legislate everything in a civil law country is if there's another word for it. So the whole idea, this is true in Israel as well. So we had to have legislation in both France and Israel to get sexual harassment. Whereas in the US, we didn't, because it's more of a common law understanding that if you have a sex discrimination argument and it fits the facts, even though there is another word for it called sexual harassment, you still can have it without legislating it. And that is not legislation, okay? So what the majority did and the dissents disagreed with was there's another word for it. It's called sexual orientation. There's another word for it. It's called discrimination against transgender people or transgender identity or gender identity. Once there's another word for it, it's good because you can organize around it, but it's trouble in places where people think you got to legislate that now, even when it comes under a pre-existing analysis called sex discrimination. And so that really is what I thought reading it. I'm thinking to myself, there's a piece of the common law you guys missed out on here. It's called seeing the facts in light of a pre-existing rubric that has already been established. And you know, that's what the majority got and the dissents missed. That was my principal takeaway from it. And then there's that outrageous appendix of Alito's with all the dictionary definitions and things in there. Boy, there's a lot of bigotry in there. And, you know, it's like reading Leviticus and saying, you know, homosexuality is an abomination, you know, but so is mixing cotton with other fibers, and, you know, slavery is just fine. Like, it had a similar kind of mix of attempted justifications to tell us that no one has ever thought anything like this before. The Kavanaugh one, you know, when he says Seneca Falls was not Stonewall, I'm like, no one said it was. Seneca Falls missed out on quite a lot. It missed on intersectionality. It missed that Black women are women in a lot of respects. Also, Seneca Falls was, I think, 1848. Stonewall, 1969, I believe. There's a lot of space in there of where people organized, made changes, moved. So who expects Seneca to be Stonewall? Anyway, yeah, we could go on about that. But I also especially missed the history of judicial recognition of discrimination on the basis of sexual orientation as linked to sex discrimination. There is a legal history to this. There's the EOC decision in Baldwin and Fox. There is the decision in Perry in California on marriage by Vaughn Walker that goes into it extensively. You know, you can find this stuff. So there's a real missing history here of recognition of this argument.
Yeah, thanks. So I know that our host, David Koss, has a question that he wants to ask. So I want to open up the space for him to do that. David.
Hi, professors. Well, actually, it's on behalf of some of the people in the audience. There's a lot of people who are not graduates of law schools or public policy schools. I read the opinions in Meritor and in Bostock, and in reading them and hearing about them, it's my inner voice was the voice of the broadcaster when the Hindenburg exploded. Oh, the inhumanity. And I think there's a lot of people who haven't been in courses or haven't studied. Could you share the facts in Meritor Savings Bank and in Bostock so that we can hear cries of, oh, the humanity from some of the people watching on the webinar that didn't have that opportunity?
Oh yeah, well, Meritor Savings Bank, Michelle Vinson was raped by her account 54 times in 2.5 years by her supervisor at the bank, who said, as he stood over her in the bank vault, waving his penis, just like I hired you, I can fire you. She was 18 years old, a young African-American woman living in Washington, D.C. inner city. It was a good job. She was good at it. She was also providing healthcare for her mother through the work. And this went on, as I said, 2.5 years. Those were the facts. The trial judge found that if the sex happened, she wanted it, which, by the way, is not a factual finding. It's a hypothetical statement. And as a result, we were able to not have it be assumed that she wanted to be sexually assaulted by someone she never said she wanted to have sex with. And so the Court of Appeals reversed that decision, and the Supreme Court, in an argument made by Patricia Barry, her longtime lawyer, and second chaired by me, I wrote the brief, together with Sally Burns, actually, and a couple of other people who helped. We won in the Supreme Court, establishing that sexual harassment, when it's a pervasive condition of your working environment, unwelcome and based on sex, that it is actionable under Title VII of the Civil Rights Act as sex discrimination. So Mark, why don't you talk about Amy Stevens maybe, or Zarda, or Bostock even. I mean, they were all fired because they were gay or trans, but the facts are pretty amazing. Zarda's facts are pretty amazing.
Yeah, I mean, these are the essential facts sort of the cases that, sort of in each one of them, you had plaintiffs who were, once known, once they're either in the 2 cases involving gay men, once their sexual orientation was known. In Amy Stevens's case, once who she was known, that it was pretty clear on the facts. There were no questions on the facts about whether they were in fact discriminated against based on their sexual orientation or their trans identity. In Amy Stevens's case, I think part of what strikes me as so interesting and important about the cases is that the actual underlying facts of the discrimination claim were so easily established. In future cases, it seems pretty clear it's going to be harder to get it sort of as cleanly in front of the courts that, particularly on appeal, that the discrimination actually happened, that the employers were saying, yeah, this is, this is what happened and it's not illegal under the law as it presently stands. So I think that there might be, that David may have a couple of questions from the audience that I want to make sure we have some time to get in.
Yeah, hi, we got, thank you for that. Also, related to that, we have 3 extraordinary questions from the audience, and people are welcome to use the Q&A feature. We are going to go till 8:15 Eastern, 5:15 Pacific. But before we do that, if I might, when you, Professor MacKinnon, graciously agreed to join us, I checked the podcast universe and places like that, YouTube and so on, for other presentations. And I found something, a presentation you made to UC Berkeley Law School students, what in our day was called Bowl Hall Law School. I think it was 2019. I was the butterfly effect in the Me Too movement. That was a good 45-minute presentation. It was probably not even the entire presentation, but if you could do a sort of précis, I think the butterfly effect, whether it's Me Too or whether it's because of the murder of George Floyd or any issue, I think it's an extraordinary comment about the powerful of ordinary people. Not that Berkeley law students are ordinary, but I think you get my drift. If you could discuss that for a few minutes, that would be great. And then I'll
Yeah, it was not to Berkeley law students. It was an international conference on global Me Too, and people came from all around the world to Bold through an international organization that's headed by David Oppenheimer there. And so what I was talking about there is the way in which the butterfly effect is something that was established scientifically in terms of a really charming metaphor, which is, the question by Lorenz, the scientist, was, does the flap of a butterfly's wing in the Amazon eventually produce a tornado in Texas? And he answered yes. And what that means is that a small local change that may appear fragile and insignificant, if it's done in an unstable environment, can eventually produce cataclysmic consequences and real change. And so I call this butterfly politics in recognition of the small moments in which interventions in what appeared to be insignificant localities. Just today, here we are giving a talk, the first surfacing of the flap of the butterfly's wing eventuated in an entire series of reasonably cataclysmic changes, of which the Me Too movement certainly is one. In other words, the original creation of sexual harassment as a legal claim has so far, among other consequences, produced millions and millions of women coming forward and lots of powerful men coming down. And so, that is the fundamental idea that, everyone is a butterfly. Everything matters. Everything you do counts. It, particularly in a system that is unstable, like sex discrimination and race discrimination. They are unstable because they're built on lies. They're built on the lie that some people are better than others on a group basis, and they're not. And it requires a lot of force to keep white supremacy in place. It requires a tremendous amount of force as well to keep male dominance in place. So white male dominance is being held up by a huge amount of force that needs to be there because it is because every day its lie is exposed by the people who are not inferior. And indeed the people who are not superior. So, that is the basic idea. And then the book collects the butterfly moments that are just mine of the first time certain ideas hit the public airwave. The first insignificant event, for example, the original testimony on the pornography idea, which is before the Zoning and Planning Commission in Minneapolis in 1983, et cetera. All of these just, one at a time and, collected all in one place. And then at the end, there's a whole set of those that have yet to become as well recognized as the earlier ones have been. But I really would like to hear questions that the audience have. So David, if you could do those, that would be great.
Yes, that was next up. Here's one. Professor, I was hugely influenced by your work in college and law school. Thank you. You mentioned that the court combined the cases in Bostock. I think you did not want to speculate in the details. This is the questioner's comment. She is curious, however, whether the court's decision to combine the cases, whatever their reason, will ultimately be harmful to women.
I actually don't think so. I think the notion that it would be suggests that finding discrimination against trans people and against gay men and lesbian women to be sex-based takes something away from women. Actually, the way I understand rights, the more other people have them on subordinated grounds, doesn't take anything away from other people who need them or need to have them recognized. Indeed, it extends them, it expands them. You know, it's not pie where you take a piece and give to somebody else gets less of it. I think that, you know, the only place where I've seen people raise a concern about whether that might be the case would be whether recognizing trans women as discriminated against based on sex takes anything away from the recognition of discrimination against women, that is all women, but in particular women who are defined, designated, assigned women based on female biology at birth, whether it takes away from the rights of women. Now, if one sees trans women as women, obviously more women have more rights when trans women's rights are recognized. If one questions whether trans women are women, which I don't, but some people do, then potentially you have that concern. The way that's been handled by any number of places, I have found to be productive. That is, for example, single-sex schools, which, by the way, cannot be said to have a legal right to exist right now, quite exactly. They are on very thin ice. But the way they've handled trans women issues is simply to say, whoever identifies as a woman at application, we will consider. And so they do, and they admit people. And similarly, if someone affirms or transitions while they are at a single-sex school for women and becomes a trans man while they are in school, they teach them and they graduate them because their mission is to teach women. And some women transition while they're at school. That's something women do, and so they graduate them. And that in no way undermines their mission of primary focus on women. So I'm just saying that's an example of one way that it expands rather than detracts from the rights that women have, including in actually a same-sex setting.
Let me move to some of the other questions. A colleague of mine on the U of M Club of DC board, who's from the Washington area, raised a question that I think I raised with both of you in phone calls. With the sort of midnight swearing in, was it last night or the night before? The phrase, one of your colleagues at Michigan Law uses the phrase, the center of gravity shifting. So let me read the question that was just posed. Can you talk about your outlook and all of these critical issues you've been discussing with whatever her name is, the recent appointment, Judge Barrett, to the court and the movement of the center of gravity?
Coney Barrett.
Sorry, thank you. Yeah.
Mm-hmm.
That was the, can you?
Yeah. It's the job of lawyers to deal with reality. And this is now reality. So it's our job to deal with it. I don't really see most of the issues that I have focused my work on, which have been issues of sexual assault, aggression, abuse, violation, from, sexual harassment through rape to prostitution and pornography as being, in essence, left-right issues. I realize that, since the French Revolution, nobody's seemed to reorient, only a few of us seem to have reoriented our politics away from the whole left-right polarity here, a bipolar vision of politics, and everything has to somehow fit into that. But I don't think that the issues that I care most about do. I think it's of real interest that the victories that have been won in sexual harassment law, which are in no way sexually regressive, but actually recognize sexual aggression as a problem for inequality, have been written by Justice Rehnquist and Justice Scalia, not exactly raging radicals of the left. And so I think our current situation is, to be very concerned, for example, about an article that Amy Coney Barrett co-authored, in which she referred, without horror, I guess I would say, to a previous article saying that there was a possibly illegitimate basis to the 14th Amendment. Well, if we're going to there, we're going to have to deal with that. I hope not. The US Supreme Court hasn't done that. I hope it isn't about to. But, one can definitely be concerned about this, as well as issues of qualified immunity, on which I take real exception to her rulings. I think it's a pernicious concept. It's totally judge-made. They didn't think they had to find a real textual basis before they did that. And it allows police officers to engage in a great deal of aggression, including particularly against Black men and Black women, and have that be found and get off the hook for it, is just a simple way of putting it. And she's roughly sided with most of those, almost all the ones that have already come before. So there's a lot to be concerned about here. But, that's got to be our agenda now.
Thank you. Let me ask the first two questions that were posed in the middle of your discussion. I'll read them, the same registrant, same attendee, in sequence. I'll just read them. She writes, in a world where there are selective abortions and where the difference between circumcision and female sexual genital mutilation comes down to the difference between the two sexes, isn't accepting that men can change sex on a whim effectively diminishing the actual relevance our female sex has in our lives, both for political and biological reasons? Let me read the second one from the same person. Related to this question, why is sex the only biological factor we accept that can be changed? Are there legal cases where other biological factors can be self-determined, for example, age?
People who transition or affirm gender are not doing it on a whim. That is a mischaracterization of what takes place. I think there are decent questions to be raised about female genital mutilation. However, the trans issues don't raise them. In other words, the way FGM typically takes place is done to very young children involuntarily, and only to female ones having their genitals either excised or otherwise cut. So the parallels don't actually apply or work here. What was the other example? It was FGM and something else, David.
Yeah, let me read the other question. She writes, why is sex the only biological factor?
Oh, that's not the question. It's the first question. And the first question had two examples. One was FGM and the other was what?
The difference, you mentioned the difference between circumcision and FGM, and is it accepting that men can change on a whim effectively diminish the actual relevance our female sex has in our lives, both for political and biological reasons?
Yeah, well, okay,
Oh,
so I'm
selective
sorry.
abortion. I'm sorry. She just texted
Selective abortion. Okay.
I
Okay, good.
apologize.
Thank you. Thank you. So I actually oppose sex selective abortions, have done so in India where they've been found to be illegal. I don't think someone should, I don't think it should be decided that you can't be born based on the sex that you are. The people who argue for the abortion right have, I think, valid questions about that position. They think that a restriction on sex selective abortions could be an undue restriction on the abortion right of a woman to terminate a pregnancy. My particular position is that any reason or no reason, not sex, not race, and then we get to disability, which is, I think, a much more important question than the one that was posed here, a much deeper one that really needs to be looked into. And, you know, the disability rights advocates argue what I'm arguing about sex, which is you shouldn't be able to abort a fetus because it is disabled. The argument being that there are people with the disabilities that people are that fetuses are aborted for, who are there to say that their lives are worth living and they're worth having. And so, you know, that's an extensive and complicated question. I would also point out, however, that I do have an argument that abortion rights should be recognized as sex equality rights. It's my argument. In anybody else's, it's never been actually fully made in a court. It's certainly never been accepted. So when it comes to the sex equality dimension of the analysis that we're discussing here, that's a subject for a whole other webinar. In other words, an abortion, an argument for a right to abortion that is a sex equality argument. And within that, one would then want to talk about sex selective abortions and the place that they have. Although, as I say, even apart from that particular argument, my argument is that sex selective abortions are amount to it says you don't get to be born because of the sex that you are. If you can't even be born based on your sex, what rights do you have? Yeah.
Right. Wow. Great. It's 18 after Eastern time, but I just want to know if either of you or both have some brief concluding or summarizing comments before I say my good nights for about 30 seconds. Either of you, please, if you have any.
I'll just
Mark,
Sure. I'll just say thank you to you, David, for organizing the panel, to Carlos for all of the incredible technical help, and to everybody in the audience who joined us here for the conversation. And last but not least, to Catharine MacKinnon for all of the thoughts on this important new decision. And I'm still thinking about David's question about sort of the butterfly effect and the remarkable possibilities, and hope that it holds out, that the actions that we all can take can make a difference. All of your work certainly has. Thank you.
Thank you, both of you. You mentioned Carlos, so I can mention him. He'll put up a slide now with recommended further reading, some great scholarship from both of you, obviously, and a podcast that I mentioned. Here we go. The good news is that everyone registered will get this via email this week, along with the other PowerPoint slides. Let me just mention that Butterfly Politics is a must read, and the podcast I didn't have the audience right. I had the location right. I guess that from the title. I guess going to Michigan helped me with that. The other are great articles. I read, Professor MacKinnon sent me the one about Lawrence v. Kansas some time ago, and there's sayings in it. I've said to both of you that should be plastered on billboard. Just incredible comments, and so all of those links will be provided. Thank you to Professor MacKinnon and Professor Spindleman for an extraordinary evening. On screen now are the recommendations, and everyone will get a list. Now, the next slide and our final slide for the evening, we can see that. Our upcoming events sponsored by the University of Michigan Club of Washington, D.C. And there are others into the new year, and you can find out all the details as they are scheduled. They'll be on umdc.org. The November 19th event is co-sponsored with the Ford School, and you can find information both on our link and on the Ford School's own website. And someone asked the question, yes, the recording of this, slightly edited, but virtually full length, will be on the University of Michigan Club Washington, D.C.'s YouTube channel at some point in the near future. We hope to see you all again. Thank you for joining us, and good night, everyone.